Thank you, Ms. Chairman. Ms. Clarke, on July 28th, the DOJ issued new guidance regarding states' efforts to remove their temporary emergency voting procedures that they implemented last year during the unprecedented COVID-19 pandemic. Did you help draft that July 28th guidance?
Yes, Ranking Member Johnson. I participated along with other career colleagues inside the department.
So since the department no longer presumes that the state election administration procedures that were in place before the pandemic are lawful, will the DOJ review how states adopted those temporary emergency election procedures during COVID-19 and whether the manner in which those temporary emergency election procedures were adopted was lawful?
Thank you, Ranking Member Johnson. As the Attorney General has made clear, protecting and safeguarding the right to vote is an important priority for the department. Right now, we are looking across the country at states that are making changes to their voting practices and rules. The point that the language that you've seized on simply states that if a state or jurisdiction decides to turn the clock back and revert back to an old practice, that we'll want to look at that with fresh eyes and understand what motivated the decision to revert back to a prior rule. Was the decision, one, infected with discriminatory purpose or intended to make it harder for particular groups to vote? So there's no presumption of validity when jurisdictions decide to turn the clock back.
It just seems like a terribly subjective determination on the DOJ's part at a time when everything is super hyper politicized, and it opens a Pandora's box, I think, for a lot of problems. Let's talk about it objectively, though. In Article 2, Section 1, Clause 2 of the Constitution, obviously it says very clearly, state legislatures are entrusted with the integrity of our unique election system, and they are given the exclusive authority to direct the manner of appointing presidential electors for the Electoral College. So as the Supreme Court affirmed in McPherson v. Blacker, that power is, quote, placed absolutely and wholly with the legislatures, and it can never be taken away nor abdicated, unquote. So every state's legislature, of course, in accordance with that, has long established detailed rules and procedures to determine their electors. But in the months preceding the 2020 presidential election, those rules and procedures were changed in some states, not by the legislatures, but by a variety of other officials, governors, secretaries of state, election officials, judges, private parties. So does the department plan to review that, since it is on its face an obviously clear violation of the plain language of Article 2?
Thank you, Ranking Member. We're committed to ensuring that every eligible American has voice in our democracy and is able to access the ballot box. And the Elections Clause of the Constitution also gives Congress the power to ensure access to federal elections. So that Elections Clause power, along with the enforcement powers that this body has by way of the 14th and 15th Amendment, truly give this subcommittee and members of the House the power to act now to ensure that no official, no jurisdiction undertakes action that could make it harder for people to vote, especially historically marginalized groups.
Let me interrupt you just for a second time. Understand what you're talking about going forward, reviewing what happens now. I'm talking about what happened last year. Is the DOJ interested in that at all? The fact that it is a blatant, on its face violation of Article 2 of the Constitution? Or are you just going to go and look at what you choose to look at? I mean, that's a serious question.
Well, we conduct very localized examinations of the voting rules in many states across the country. And there is no presumption of validity. We are going to conduct an intense appraisal of the facts on the ground to understand if a particular law or change violates federal laws that the Justice Department has jurisdiction to enforce.
Okay, real quick, the data from recent elections and the DOJ enforcement activity following Shelby County suggests that there is no need to amend the VRA. Are you aware that the Census Bureau data concludes that African Americans in Georgia register to vote and vote in elections at a higher rate than African Americans in the Democrat-controlled states of Illinois, New York, and California?
I thank you, Ranking Member. I think those registration rates are an important data point for this subcommittee to study. I think it's also important to look at conditions on the ground. That's what Justice Robert urged Congress to do. And when we look at the current conditions, we see that there are, in many places, voters of color, Black voters, Latino voters, and others who are subjected to long lines, voters who have difficulty accessing polling sites because polling sites are being shut down in their particular communities. And so looking comprehensively at the facts, I think, is what can help Congress undertake what the court asks, and that is really truly looking at current conditions.
I'm out of time, but let's also note that Arizona has a higher voter turnout for minority groups than California.